Good morning, everyone. Would the registrar please call the case?
Thank you and good morning, Your Honours. This is case number IT 955/18T, the prosecutor versus Radovan Karadžić.
Thank you. May I have the appearances for the prosecution, Mr. Tiger?
Good morning, Mr. President, Your Honors. Alan Teeger, Hildegard Ertzretzloff, and Ian Reed appear for the prosecution.
Thank you, Mr. Tiger. As for the defense?
Sa mnom je moj pravni savjetnik, gospodin Peter Robinson.
I'm not sure we are getting the English translation. Could you repeat, Mr. Karadžić?
Dobro jutro, ekscelencije.
Good morning, Your Excellencies. Good morning to all. I have with me here today my legal counselor, Mr. Peter Robinson, and I also have a case manager nearby.
Good morning, Your Honours. Richard Harvey, lead standby counsel, assisted by Mariana Vukajlovic.
Thank you, Mr. Harvey. I'm not sure if the French translation is being done. The chamber convened this hearing to deliver its ruling on the accused oral motion for a judgment of acquittal pursuant to Rule 98 bis of the Tribunal Rules of Procedure and Evidence. On the 11th of June 2012, the accused moved for a judgment of acquittal on each of the 11 counts in the indictment. The prosecution responded on 13th of June 2012, opposing the motion. The chamber will start by recalling the applicable legal standard. Rule 98 bis, as amended in 2004, provides that at the close of the prosecutor's case, the trial chamber shall, by oral decision and after hearing the oral submission of the parties, enter a judgment of acquittal on any count if there's no evidence capable of supporting a conviction. As enunciated in numerous Rule 98 bis decisions, including the cases against Mirkusic et al., Popovic et al., and Milutinovic et al., the test to be applied is whether there's evidence upon which, if accepted, a reasonable trier of fact could be satisfied beyond reasonable doubt of the guilt of the particular accused on the count in question. The test is not whether a trial chamber would convict beyond reasonable doubt, but rather whether it could do so. Therefore, where there is no evidence to sustain a count, or where the only relevant evidence is so incapable of belief that it could not properly sustain a conviction, even when the evidence is taken at its highest for the prosecution, a judgment of acquittal will be entered with respect to that count. At this stage, the trial chamber is not to evaluate the credibility of witnesses or the strengths and weaknesses of contradictory evidence. Furthermore, a ruling now that there is evidence capable of sustaining a conviction on a particular count does not mean that the trial chamber will enter a conviction at the end of the case. The chamber also notes that where evidence is mentioned later in support of its finding, the fact that it has been considered for the purpose of this ruling is no fixed indication that the chamber will ultimately accept it in whole or in part. Similarly, the fact that certain evidence is not mentioned in the Rule 98 bis rulings does not mean that the Chamber may not accept it and rely upon it in its final judgment. The rule also does not require that the Chamber be satisfied that there is evidence supporting each of the individual charges making up a specific count. For instance, for persecutions under count 3, it is sufficient that there be evidence on one or several forms of persecutions alleged. It is also sufficient if there is evidence capable of supporting a conviction on the basis of one of the modes of responsibility charged in the indictment. Although the accused has challenged all of the modes of responsibility, this decision concentrates on assessing the responsibility of the accused on each of the 11 counts for commission under Article 7.1 of the Tribunal's statute through his participation in the 4 alleged joint criminal enterprises. Only if there were no evidence under this mode of responsibility would the Chamber turn to the other modes under Articles 7.1 and 7.3 of the statute. The Chamber wishes to make 2 preliminary notes. First, with regard to the accused challenge in relation to the overly broad use of the term Bosnian Serb forces. The Chamber recalls paragraph 32 of the decision on 2 motions alleging defects in the form of the indictment issued by the pretrial chamber in this case on the 12th of May 2009, in which it found that the indictment was not defective in regard to the specificity of pleading the identity of the alleged members of the joint criminal enterprises and the physical perpetrators. The Chamber further notes that throughout this ruling, it will use the term Bosnian Serb forces as defined by the prosecution in paragraph 14b of the indictment. Second, the Chamber notes that for the purpose of this ruling, it will use the term of municipalities as defined by the prosecution in paragraph 48 of the indictment. The Chamber will present its ruling first in relation to the hostages component of the case, before turning to the Sarajevo component, then the Srebrenica component, and finally concluding with the municipalities component. The Chamber now turns to the accused challenges in relation to the hostages component of the case. As part of his challenges, the accused submits that the detained UN personnel were combatants taking part in the hostilities and that Article 3 of the statute encompasses protections guaranteed by Common Article 3 of the Geneva Conventions of 1949 and thus only protects persons who are taking no active part in hostilities. In relation to his mens rea, he further submits that he considered at the time of their detention that the UN personnel were being detained as prisoners of war. The prosecution responds that the status of UN personnel is irrelevant because Common Article 3 protects persons taking no active parts in hostilities, including members of the armed forces, who have laid down their arms and those placed hors de combat by their detention. The prosecution further responds that any statements by the accused that the detained UN personnel were prisoners of war is contradicted by evidence showing his intent to gain an advantage or obtain a concession as a direct consequence of their detention. The Chamber would not determine at this stage what constitutes the legal elements of the crime of hostage-taking under the statute. However, the Chamber recalls that the Appeals Chamber in this case, in its decision on appeal of Trial Chamber's decision on preliminary motion to dismiss count 11 of the indictment, issued on the 9th of July 2009, held that Common Article 3 prohibits hostage-taking of any person taking no active part in the hostilities, including those placed hors de combat by detention. It is therefore sufficient to note that even if the UN personnel were combatants immediately before their detention, they were rendered hors de combat by virtue of their detention, and thus were entitled to the minimum protections guaranteed by Common Article 3. The Chamber received evidence from Patrick Reckner, Joseph Gallison, and Marcus Helgers, who were UN personnel in 1995, detained by the Bosnian Serb forces and placed in areas of military significance for the Army of Republika Srpska, also known as the VRS. They were threatened with death unless NATO stopped their airstrikes against Bosnian Serb military targets. The Chamber also heard evidence from Reckner, Helgers, and Rupert Smith that the threats were communicated both to the detained UN personnel directly, as well as to Smith and the headquarters of the United Nations Protection Force, also known as UNPROFOR. Accordingly, the Chamber finds that there is evidence on which, if accepted, a reasonable trier of fact could be satisfied beyond reasonable doubt that the crime of taking hostages as a violation of the laws or customs of war under Article 3 of the statute, and specifically Common Article 3, was carried out by Bosnian Serb forces between May and June 1995. Turning now to the accused responsibility under count 11, the Chamber heard evidence from Smith and has admitted documents such as P2137, P2149, P2268, and P5013, all of which indicate that following the NATO airstrikes, the Bosnian Serb political leadership and the VRS enacted a plan to detain UN personnel and place them in locations of military significance for the VRS. The objective of this plan was to stop NATO from continuing further airstrikes, as shown by the threats made to the UN that the detained personnel would be killed if another airstrike occurred. The same evidence also indicates that the members of the Bosnian Serb political leadership and military who participated in this plan included the accused and Ratko Mladic. Accordingly, the Chamber is satisfied that there is evidence upon which, if accepted, a reasonable trier of fact could find beyond reasonable doubt that there existed a joint criminal enterprise, the common purpose of which was to take UN personnel hostage in order to compel NATO to abstain from conducting further airstrikes against Bosnian Serb military targets, and which involved a plurality of persons, including the accused. In relation to the accused contribution specifically, the Chamber received evidence that by virtue of his position as the Supreme Commander of the VRS and President of the Republika Srpska, he approved orders issued by the VRS to detain UN personnel. These are P2137 and P5026. The Chamber also heard from Smith that prior to the detention of UN personnel, the accused told him that if NATO were to conduct airstrikes against Bosnian Serbs, the Bosnian Serbs would treat the UN as their enemy and would attack or detain UN personnel. This is confirmed by P2264 and P2265. The Chamber also received evidence indicating that the accused shared the intent to take the UN personnel hostage. For example, as can be seen from P2137, the accused approved an order on the 27th of May 1995 directing the VRS to place UN personnel in locations of potential targets for the NATO airstrikes. On the 29th of May 1995, the accused, in a telephone conversation which included Karadžić, stated that his demand as a condition for the release of the UN personnel was that there would be no more NATO airstrikes. This is P5626. Later, on the 15th of June 1995, at the 51st session of the RS Assembly, the accused stated that the Bosnian Serbs had released most of the UN personnel except for the 15 people who are still being detained for the purpose of trying to keep the VRS weapons in Sarajevo, and added that, I quote, "We even somewhat benefited from this whole crisis," unquote. This is Exhibit P1410. Accordingly, the Chamber is satisfied that there is evidence upon which, if accepted, a reasonable trier of fact could find beyond reasonable doubt that the accused voluntarily participated in a joint criminal enterprise, the common purpose of which was to take UN personnel hostage in order to compel NATO to abstain from conducting further airstrikes against Bosnian Serb military targets. There is also evidence to suggest that he shared the intent of the other members of this joint criminal enterprise to carry out its objective. The Chamber will now deal with the accused challenges as they concern the Sarajevo component of the case. In relation to count 5 and 6, the accused submits that there is no evidence of his mens rea in terms of planning, aiding, abetting, instigating, and committing murders. Because the accused also submits in relation to his challenges to count 9 and 10 that there is no evidence that any sniping or shelling incident was committed from the Serb side, the Chamber understands his challenge to also cover the actus reus of murders alleged to have occurred in Sarajevo. The prosecution responds that evidence shows that civilians in Sarajevo were frequently targeted by Bosnian Serb fire. The Chamber will first address the issue of whether there is evidence that murders occurred in Sarajevo and were committed by Bosnian Serb forces. The Chamber has received a large body of evidence going to the killings that took place in Sarajevo, as well as to the fact that these were committed by Bosnian Serb forces. For example, Bakir Nakash, Fatima Zaimovic, and Dragan Miokovic testified generally about a large number of persons killed in Sarajevo as a result of the shelling and sniping in the city. In addition, there is also testimonial and documentary evidence relating to a number of scheduled shelling and sniping incidents which resulted in deaths and which were said to have been committed by Bosnian Serb forces. As an example, in relation to scheduled shelling incident G6, where a number of children died as a result of shelling while playing football in Dobrinja, the Chamber received not only testimonial evidence, but also evidence in the form of investigative reports prepared at the time by the BIH Ministry of Internal Affairs, also known as BIH-MUR, as well as by UNPROFOR, all pointing to the Bosnian Serb forces as the perpetrators. The Chamber refers here to P1443 and P1698. Accordingly, the Chamber finds that there is evidence on which, if accepted, a reasonable trier of fact could be satisfied beyond reasonable doubt that murder, charged as a crime against humanity pursuant to Article 5A of the statute, and as a violation of the laws or customs of war under Article 3 of the statute, and specifically Common Article 3, were carried out by Bosnian Serb forces in Sarajevo. In relation to counts 9 and 10, the accused submits that there is no evidence of the existence of a siege in Sarajevo, but rather the Bosnian Serbs conducted a military policy of quote and unquote containing the First Corps of the Army of Bosnia and Herzegovina, also known as ABIH. He also submits that there is no evidence of terror in Sarajevo, or that any sniping or shelling incident was committed from the Serb side, or that the Serb side fired indiscriminately. Finally, he claims that there is no evidence that Sarajevo was a civilian zone, or that it was the target of any militarily unjustified action by the Serb side. In response, the prosecution refers to numerous witnesses who have testified that the campaign of shelling and sniping conducted by Bosnian Serb forces was intended to inflict terror on the civilian population, that the fire directed against Sarajevo was indiscriminate, and that it was directed primarily at the civilian population. The chamber notes that a number of witnesses testified that the city of Sarajevo, together with its civilians, was in fact encircled or besieged by Bosnian Serb forces, and not just contained for a military purpose. The chamber refers here to the testimony of Com Doyle, Jeremy Bowen, and Richard Moll, and as well as to D235. These witnesses, in addition to Anthony Banbury, Pius Tucker, David Harland, and Herbert Okun, also testified that while besieged, the city was constantly shelled and sniped by the Bosnian Serb forces, using indiscriminate and disproportionate fire with the intent to terrorize the civilian population, including women and children. Indeed, many witnesses used the term terror during their testimony. The chamber has also been provided with both testimonial evidence, such as the evidence of Ekrem Sulevich, Milomir Shoya, and Harry Konings, and documentary evidence such as P1201 and P1310, going to the use by the Bosnian Serb forces of highly inaccurate and highly destructive modified air bombs. Accordingly, the chamber finds that there is evidence on which, if accepted, a reasonable trier of fact could be satisfied beyond reasonable doubt that the crimes of terror and unlawful attacks charged under Article 3 of the statute were carried out by Bosnian Serb forces in Sarajevo. The chamber now turns to the accused responsibility for counts 5, 6, 9, and 10, still in relation to Sarajevo. Some of his challenges mentioned earlier, such as his submission that there was no terror in Sarajevo, or that he had no mens rea to commit murders, also pertain to his responsibility. In addition to those challenges, he submits that there was no motive for the Serbs to terrorize the population in Sarajevo, as the Serbs were not seeking to capture the territory in and around it. The prosecution responds that these assertions are directly contradicted by the weight of the evidence. First, the chamber has heard from a number of witnesses, including Harland, KDZ 088, and Okun, that the Bosnian Serb military and political leadership, including the accused, Krajisnik, Biljana Plavsic, Nikola Koljevic, Mladic, and Stanislav Galić were in general united in their position when it came to Sarajevo. For example, Okun testified that one of the Serb goals was the division of Sarajevo into Serb and Muslim parts, and that this was the constant refrain of Bosnian Serb leadership during the peace negotiations. Second, the Chamber recalls the evidence briefly referred to earlier in relation to the campaign of sniping and shelling in Sarajevo as charged under Count 9. In addition, and with respect to the accused challenge that Bosnian Serbs had no motive to terrorize the city, the Chamber has heard from a number of witnesses such as Doyle, Mole, Michael Rose, and Haaland contradicting that assertion. For example, Haaland testified that the overall strategy of the Bosnian Serb leadership, and in particular that of the accused, was to modulate the level of suffering in Sarajevo as it suited his political goals, increasing it to force the Bosnian Muslims to accept peace deals on Serb terms and preserve territorial status quo, or reducing it in the face of threats of international military intervention. Accordingly, the Chamber finds that there is evidence upon which, if accepted, a reasonable trier of fact could be satisfied beyond reasonable doubt that between April 1992 and November 1995, there was a joint criminal enterprise to establish and carry out a campaign of sniping and shelling against the civilian population of Sarajevo. There is also evidence upon which, if accepted, a reasonable trier of fact could be satisfied beyond reasonable doubt that the objective of this joint criminal enterprise involved the commission of crimes of terror, unlawful attacks on the civilians, and murder. With respect to his own contribution to the events in Sarajevo, the accused submits that there is no evidence that he had anything but a positive attitude on the delivery of humanitarian aid to the city. He also mentioned difficulties in controlling a popular army consisting of soldiers who were locals and former residents of Sarajevo. The prosecution responds that these assertions are directly contradicted by the weight of the evidence, and that, on the contrary, the very nature of the campaign against the city shows that the accused was in overall control over the shelling, the sniping, and the terror. The Chamber has heard extensive evidence about the accused being both the president of the Republika Srpska and the supreme commander of the VRS, as shown by P3036, which gave him broad de jure and de facto powers of those forces, including the Sarajevo-Romania Corps, also known as the SRK, and which ensured his presence at various negotiations relating to Sarajevo. The Chamber also heard ample evidence about the accused involvement in the events in Sarajevo as alleged in paragraphs 14 and 19 of the indictment. For example, the Chamber heard that during his speech at the 16th Assembly session of the Serbian Republic of BiH of 12th of May 1992, the accused explained with respect to Sarajevo that, I quote, "The battle in Sarajevo and for Sarajevo, seen strategically and tactically, is of decisive importance because it does not allow the establishment of even the illusion of a state," unquote, and stated that, quote again, "Alija does not have a state while we have a part of Sarajevo," unquote. The accused also stated that, quote, "The fighting in Sarajevo keeps the fighting far away from all those areas where we could possibly have conflicts with Muslims," unquote. Noting also that, as the Bosnian Serbs expected, quote, "If there's a war, it would start in Sarajevo and end in Sarajevo, unquote. These are quotes from P956. Haaland testified that in line with the Serb leadership's strategy to terrorize the city for political gains, the accused told him that it would not be politically useful to force the city to surrender, as this would prompt a Western military response. The chamber also notes here the evidence of KDZ 088. In relation to the accused's challenge that it was difficult to control a popular army of soldiers who were Sarajevo locals, the chamber has heard evidence to the effect that the accused was in complete de jure and de facto control over the VRS. The chamber refers to D325 and the testimony of John Wilson, Haaland, and Rose. Also, Oken testified that the accused said to him in September 1992 that the VRS had a unified command and that he had full power over it, including over 95% of the irregulars. The chamber also heard evidence from Oken, Wilson, and Haaland that the accused justified the activities of Bosnian Serbs in Sarajevo, stating that they were conducted in self-defense or in response to provocation by the Bosnian Muslims. Haaland also added that during their meetings, the accused would be presented with information about specific shelling or sniping incident, but would normally deny that there was a problem, or would say that he would look into it, or that he had already issued orders that the firing should stop. According to Haaland, such promises by the accused had very little effect. Contrary to the accused's submission, the chamber also heard evidence from Haaland, Smith, and Rose about the accused directing and or authorizing the restriction of humanitarian aid to Sarajevo. Haaland testified that the accused would use 8 levels of pressure on Sarajevo, one of which was the control over humanitarian supplies, and would often stop the supplies from coming into the city when there was no threat of a NATO intervention. Haaland also testified that on 26th of July 1994, the accused decided to close 2 of the blue routes used to deliver humanitarian aid, and that on the 8th of April 1995, he decided to close Sarajevo altogether by halting the Sarajevo airlift. Accordingly, the chamber is of the view that there is evidence upon which, if accepted, a reasonable trier of fact could be satisfied beyond reasonable doubt that the accused voluntarily participated in the joint criminal enterprise relating to Sarajevo through both his acts and omissions, and that he shared the intent of the other members of this joint criminal enterprise to carry out its objective, namely to establish and carry out a campaign of sniping and shelling against the civilian population of Sarajevo with the intent of spreading terror. There is also evidence to suggest that he shared the intent of the other members of the joint criminal enterprise to commit the crimes of murder, terror, and unlawful attacks on civilians. The chamber will now deal with the accused challenges regarding the Srebrenica component of the case. In relation to counts 4, 5, and 6 in Srebrenica, the accused submits that there is no evidence that civilians were killed and makes a number of challenges to specific killing incidents. The prosecution responds, citing evidence to the contrary. The chamber has received a considerable body of evidence suggesting that a substantial number of unarmed Bosnian Muslims were killed in Srebrenica by Bosnian Serb forces during the period alleged in the indictment. The Chamber refers, for example, to KDZ 039 and KDZ 064 in relation to Orahovac, to KDZ 066 in relation to Cherska Valley, to KDZ 084 in relation to Sandic, and to Amo Hasic and Dražan Erdemovic in relation to Branjevo farm. Additionally, the Chamber heard evidence from KDZ 063 and KDZ 071 in relation to the killing on the 13th of July 1995 of hundreds of Muslim men in a warehouse in Kravica, which goes against the accused challenge as to why the Kravica incident occurred. Furthermore, the Chamber heard evidence from KDZ 065 in relation to the killing on the 13th of July 1995 of Bosnian Muslim men at the bank of the Jadar River, which goes against the accused challenge that there is no evidence proving killings before the Kravica incident. The Chamber also heard evidence from Johannes Rutten and Paul Groenewegen in relation to killings in Potocari on or about 12th and 13th of July 1995, which goes against the accused challenge that there were no killings in places where there was a greater military or police presence, such as in Potocari. The Chamber also received extensive evidence regarding the presence of Bosnian Serb forces in the Srebrenica area, which were involved in the alleged commission of crimes against Bosnian Muslims. For example, the Chamber received evidence from KDZ 064, KDZ 084, Dragan Jovic, Sretko Acimovic, Mevludin Oric, and Erdemovic on the presence of, inter alia, security officers from various VRS units and members of the RS MUP, the 10th Sabotage Detachment, and the Zvornik Brigade's 2nd and 4th Battalions at various execution sites. Accordingly, the Chamber finds that there is evidence on which, if accepted, a reasonable trier of fact could be satisfied beyond reasonable doubt that murder, charged as a crime against humanity pursuant to Article 5A of the statute and as a violation of the laws or customs of war under Article 3 of the statute, and specifically Common Article 3, and extermination charged as a crime against humanity pursuant to Article 5B of the statute, were carried out by Bosnian Serb forces in the Srebrenica area in 1995. The Chamber will now turn to the accused challenges in relation to counts 7 and 8, insofar as they relate to Srebrenica. The accused submits that there was no planned deportation, but that by the 11th of July 1995, the Bosnian Muslims in Srebrenica wanted to be evacuated and conveyed that request to Mladic and the UN. The prosecution submits, on the contrary, that there was a clear intent by the accused and the VRS to forcibly displace the population, and that the desperate conditions imposed by them on the enclave were intended to make life unbearable in the months leading up to the attack, contributing to the population's lack of any other choice but to leave the enclave. The Chamber notes that it will not make a determination at this stage as to what constitutes a de facto or de jure border for the purposes of deportation. The Chamber heard evidence from Joseph Kingery, Rutten, and Robert Franken that when the Srebrenica enclave fell to Bosnian Serb forces, the Bosnian Muslim population had no other choice but to leave Srebrenica town and move to Potocari. Kingori and Christine Schmidt both testified about the dire humanitarian situation faced by approximately 20,000 refugees in Potocari due to the lack of food and medical supplies. The chamber also received evidence from various witnesses, including KDZ 070, KDZ 186, and Rutan, about the forcible displacement of thousands of Bosnian Muslim women, children, and elderly men from Potocari in July 1995, when they were ordered by the VRS soldiers to board buses. The chamber also heard from Kingori and Mile Janic that the forcible displacement of population from Srebrenica was planned by the VRS. There is also testimonial documentary evidence, such as the evidence of Kingori and P1385, suggesting that the goal of the Bosnian Serb leadership in organizing the forcible displacement was to permanently remove the Bosnian Muslims from Srebrenica. The intent of Bosnian Serb forces to forcibly displace the Bosnian Muslims in Srebrenica is shown by the organization of the transportation for the refugees in Potocari and the systematic nature in which the women, children, and some elderly men were separated from the military-aged men and taken towards Bosnian Muslim-held territory, as shown, for example, by the testimony of KDZ 070, Hasic, Groenewegen, and Evert Albert Rave, and by P4935 and P4464. Further evidence supporting the intent to forcibly displace this population is shown in P4075, a Bratunats Brigade report of the 4th of July 1995, setting forth the goal for the civilian population of Srebrenica that, I quote, their life has to be made unbearable and their temporary stay in the enclave impossible, so that they leave the enclave en masse as soon as possible, realizing that they cannot survive there, unquote. Accordingly, the chamber is satisfied that there is evidence upon which, if accepted, a reasonable trier of fact could find beyond reasonable doubt that the crimes of deportation and forcible transfer, an inhumane act as crimes against humanity, and charged under Article 5D and 5I of the statute, were carried out by Bosnian Serb forces in Srebrenica in July 1995. The accused does not raise any specific challenges to count 3 with respect to Srebrenica, although some of the submissions he made in relation to the killings and the forcible displacement of the population from Srebrenica could also be considered as challenges to count 3. The evidence before the chamber in relation to forcible displacement and killings in and around Srebrenica in 1995, as already addressed earlier, suggests that the events occurred according to a persecutory pattern of behavior. This pattern can first be inferred from the evidence on the number of Bosnian Muslim victims killed in Srebrenica, as evidenced by, among others, the testimony of Eva Tabo and Dusan Jant, as well as by the number of victims transferred to Bosnian Muslim-held territory and the organized way in which the forcible displacement was carried out in a short period of time. Furthermore, the chamber heard evidence suggesting that Bosnian Muslims in Srebrenica were killed on the basis of their ethnic and religious affiliation, thus indicating that the killings were therefore carried out with the requisite persecutory intent by the Bosnian Serb forces. Similarly, in relation to the specific intent required for the forcible displacement of people out of pottery to constitute persecutions, the Chamber has received evidence suggesting that Bosnian Muslims were subject to forcible displacement on the basis of their ethnic and religious affiliation. Therefore, the perpetrators acted with the requisite specific intent to discriminate on political, racial, or religious grounds. Accordingly, the Chamber finds that there is evidence on which, if accepted, a reasonable trier of fact could be satisfied beyond reasonable doubt that the persecutions charged as a crime against humanity pursuant to Article 5H of the statute were committed in Srebrenica in July and August 1995 by Bosnian Serb forces against Bosnian Muslims with the intent to discriminate against them specifically based on political, racial, or religious grounds. The Chamber now turns to the accused challenges in relation to Count 2, genocide, Srebrenica. In addition to the accused challenges to the killings per se, which have already been dealt with earlier, the accused submits that there is no evidence on the perpetrator's intent to destroy the Bosnian Muslims in Srebrenica. As discussed earlier in relation to counts 4, 5, and 6, there is evidence before the Chamber that the military-aged Bosnian Muslim men in Srebrenica were the target of large-scale killings. This indicates that the part of targeted group within the meaning of Article 4 of the statute was indeed the Bosnian Muslims in Srebrenica as part of the Bosnian Muslim national, ethnical, and or religious group as such, as alleged in paragraph 41 of the indictment. Accordingly, the Chamber finds that there is evidence on which, if accepted, a reasonable trier of fact could be satisfied beyond reasonable doubt that the Bosnian Muslims in Srebrenica were targeted for destruction. In relation to the accused challenge, as to the lack of genocidal intent of the physical perpetrators of the killings in Srebrenica, the Chamber recalls that the specific intent of such perpetrators, by its nature, is not usually susceptible to direct proof, but can be inferred from various factors, including the general context of the case, the numerical size of the atrocities committed, the repetition of destructive and discriminatory acts, or the existence of a plan or policy to commit the underlying offense. In this respect, the Chamber refers to the Jelisic and Kristić appeal judgment. First, the evidence before the Chamber on the scheduled incidents as a whole suggests that killings were organized on a large scale, similarly to a military operation. In addition to the extensive evidence before the Chamber on the presence of various VRS and MUP units in Srebrenica, as discussed in relation to counts 4, 5, and 6, the Chamber also received evidence, including from Milenko Katanić, on the assistance of local authorities in the burial of bodies after the mass executions. Accordingly, the evidence before the Chamber on the number of victims killed, as well as on the facts that only Bosnian Muslim men and boys were targeted for summary executions, and that the Bosnian Serb forces tried to kill each and every able-bodied Bosnian Muslim man in Srebrenica, suggests the systematic nature and scale of the crimes committed, as well as the systematic targeting of the group. Accordingly, the Chamber finds that there is evidence on which, if accepted, a reasonable trier of fact could be satisfied beyond reasonable doubt that genocide charged pursuant to Article 4 of the statute was carried out by Bosnian Serb forces in Srebrenica. The Chamber now turns to the accused responsibility for counts 2 to 8 inclusive, still in relation to Srebrenica. The accused submits that the combat activities in Srebrenica had a legitimate military purpose, that the question of the VRS entering Srebrenica only became relevant on the night of 10th of July 1995, and that the VRS only entered Srebrenica once the town was abandoned by the 28th ABIH Division and the civilian population. The prosecution submits, on the contrary, that the operation to take Srebrenica was a culmination of the accused efforts to ethnically cleanse eastern Bosnia, and refers to evidence showing contact by the VRS with civilians in Srebrenica town on the 11th of July 1995. First, the Chamber heard evidence that as early as 1992 and continuing until the 11th of July 1995, the Bosnian Serb leadership implemented a policy which resulted in the large-scale expulsion of the non-Serb population from Bosnian Serb claimed territories in BiH, and specifically in the permanent removal of Bosnian Muslim populations in Srebrenica. This policy was first formulated by the accused in May 1992 through the 6 strategic goals, and following the creation of the VRS and the appointment of Mladic as the commander of the VRS main staff, implemented through the issuance of a number of successive operational directives, as well as by the issuance by the Drina Corps of Order Krivaya 95 on the 2nd of July 1995, which culminated in the attack on the Srebrenica enclave a few days later. The documentary evidence before the Chamber in support of this policy includes P781, P838, P961, P976, P2246, and P4481. There's also evidence suggesting that the accused approved the Srebrenica operation as illustrated by his own statement at the 52nd and the 54th sessions of the Republika Srpska Assembly in August and October 1995, as well as during a television interview. These are P1412, P1415, and P4555. The Chamber also heard evidence indicating that as the Srebrenica enclave fell, the Bosnian Serb leadership implemented a policy to eliminate the Bosnian Muslim population in Srebrenica. There's evidence that shows the heavy VRS offensive, as shown in documents P4143 and P4147, led to the fall of Srebrenica town on the 11th of July 1995. Video footage taken at the time shows that once Srebrenica town was taken, Mladic, Zivanovic, Radislav Kristic, Vujadin Popovic, Vinko Pandurevic, and other Bosnian Serb forces advanced onwards towards Potocari, where part of the civilians had fled, and then towards Bratunac. This is P4201. The Chamber also refers to P2992, Contrary to the accused's submission that the VRS only entered Srebrenica town once it was abandoned by the civilian population and the ABIH 28th Division, the chamber heard evidence from Ed Demovic, a member of the VRS 10th Sabotage Detachment, that his unit established contact with the Bosnian Muslim population, including some elderly people and a military-aged man, upon his surrender in the center of Srebrenica town on the 11th of July 1995. The chamber received evidence from Kingori as well as from P4935 and the video footage admitted as P4201 on the meetings held at the Hotel Fontana in Bratunac on the 11th and 12th of July 1995 with Judgement officials, Mladic, and other members of Bosnian Serb forces. This evidence indicates that during these meetings, Mladic told the Bosnian Muslim civilian representatives, quote, "You can either all leave, all stay, or all die here," unquote. Mladic also told them to bring the people who can secure the surrender of weapons and save their people from destruction. The evidence before the chamber discussed earlier in relation to counts 2 through 8 shows the separation of Bosnian Muslim men of military age from the Bosnian Muslim women, children, and elderly men by the VRS. Bosnian Muslim women, children, and some elderly men were subjected to forcible displacement, while the military-aged men were taken to various locations and executed. The evidence cited previously in relation to count 2 to 8 inclusive also shows the organized and systematic manner in which the VRS acted to implement the policy to eliminate the Bosnian Muslims in Srebrenica. Accordingly, the chamber is satisfied that there is evidence upon which, if accepted, a reasonable trier of fact could be satisfied beyond reasonable doubt that there existed a joint criminal enterprise composed of members of the VRS, MUP, and the Bosnian Serb leadership, including the accused, the purpose of which was to eliminate the Bosnian Muslims in Srebrenica. With respect to his own contribution to the events in Srebrenica, the accused submits that there is no evidence that he planned, instigated, ordered, and or aided and abetted genocide in Srebrenica, nor as to who made the decision on the genocide and the killings in general. The accused adds that he could not and did not have knowledge of what was happening on the ground, both in relation to the killings or the forcible displacement in Srebrenica. The prosecution responds that, on the contrary, the accused was constantly kept abreast by the VRS, the MUP, and the civilian authorities of developments on the ground, and that he knew of the forcible displacement and killing as they were happening. As stated earlier, the chamber has heard ample evidence, including the testimony of Milovanovic and Skrubic, and as shown by P3036, about the accused role as President of the Republika Srpska and Supreme Commander of the VRS, which gave him broad de jure and de facto powers over those forces, including all the VRS units deployed in Srebrenica. This is confirmed by the accused's own statements during the 39th session of the RS Assembly that, I quote, "I am the one who signs, who decides, and I will be responsible for each decision," unquote. This is P1388. The Chamber also heard ample evidence about the accused involvement in the events in Srebrenica, as alleged in paragraphs 14 and 24 of the indictment. Contrary to his challenge that he did not and could not have had knowledge of what was happening on the ground during the Srebrenica operation, the Chamber received evidence on the flow of communication up and down the chains of command in the VRS, the police, and the State Security Service, as well as between different reporting entities. The Chamber refers inter alia to the evidence of Christian Nielsen and to P2984, P2996, P4450, P4932, and D2099. Generally, in relation to information coming from the VRS, there's documentary evidence showing that that daily reports were sent to the accused by the main staff, at least from 12th to 14th of July 1995. These are P3054, P4457, and P4464. In addition, the Chamber heard evidence from Slavica Ristic, Tomislav Premovic, and Robert Djurdjevic on the accused's direct communication with Mladic on the 13th and 14th of July 1995 regarding the Srebrenica operation. The evidence also indicates that the accused was receiving information from the MUP, as exemplified by the meetings between the accused and Tomo Kovac on the 13th, 14th, 15th, and 18th of July 1995, and by the fact that Kovac was receiving intelligence information reports from the field. The Chamber refers to P2242, P2987, P4932, P4933, and P5137. The Chamber also heard evidence from Karadžić that Miroslav Deronic communicated by telephone almost daily with the accused during the Srebrenica operation, as confirmed by their conversation on the 13th of July 1995, in which Deronic reported to the accused about approximately 2,000 Bosnian Muslims from Potocari who were transported and detained in Bratunac. This is P4618. The accused also met with Deronic on the 14th of July 1995, as indicated by P2242, P4382, and Djurdjevic's evidence. In relation to the accused's challenge as to his knowledge of the killing in Srebrenica, the Chamber heard evidence, including that of KDZ 122, that members of the VRS chain of command were aware of orders to kill the Bosnian Muslim men from Srebrenica. The Chamber also heard evidence from Karadžić about a meeting between Deronic and the accused, where Deronic allegedly reported on the killings in Kravica on the 13th of July 1995. As for the accused's submission that there's no evidence that he knew or contributed to any deportation in Srebrenica, the Chamber refers to documentary evidence indicating that the accused was being informed by the VRS main staff as early as 12th of July 1995 of the organized transport of about 10,000 Bosnian Muslims from Potocari towards Kladanj. The Chamber here refers to P166, P3054, P4388, and P4464. The Chamber has also heard evidence of the accused's encouragement of the VRS involved in the Srebrenica operation. Specifically, the Chamber received documentary evidence such as P1412, P4501, P4555, and P5121, as well as the testimony of Skribic, Jurjevic, and Premovic in relation to the promotion of Kristić on the 13th of July 1995 to Corps Commander of the Drina Corps immediately after the fall of Srebrenica as a result of his direct involvement in the planning of the taking over the Srebrenica enclave. As discussed earlier, the Chamber has heard evidence indicating that genocidal acts took place in the Srebrenica area in the summer of 1995 and that they were committed with the requisite specific intent for genocide. In light of all the evidence presented, the Chamber is of the view that the accused genocidal intent may be inferred from the evidence received on the systematic nature and scale of the crimes committed in Srebrenica, as well as from the evidence on the targeting of the specific group of Bosnian Muslims and the accused acts and omissions in relation to the events that took place there in 1995, as discussed earlier. Accordingly, the Chamber is of the view that there is evidence upon which, if accepted, a reasonable trier of fact could be satisfied beyond reasonable doubt that the accused voluntarily participate in a joint criminal enterprise, the common purpose of which was to eliminate the Bosnian Muslims in Srebrenica through the commission of the crimes as charged in paragraph 20 of the indictment. There is also evidence to suggest that the accused shared the intent of the other members of this joint criminal enterprise to carry out its objective, including the specific intent to commit genocide and the specific intent to discriminate against the Bosnian Muslims in Srebrenica, specifically based on political, racial, or religious grounds. Before we turn to the municipalities component, given the timing, the Chamber will take a break for 15 minutes.
All rise, we will